Awesome. Thanks so much for coming along today to our How to Mediation session. Feel free to turn on your cameras if you like, I don't mind. But my name is Matisse, so I am a student, a fifth year law arts student. Hey, Grace. Here at UQ. I have been involved with a few mediation, or with the UQ's ADC ICC international mediation competition. So I was a student in that competition in 2020, which was the first year that UQ entered. And so that's why I'm delivering the How to Mediation competition, as this is the first year that the UQLS is going to be running an internal mediation competition, which is super exciting. So I might start by sharing my screen for these slides. Can everyone see that all fine? Awesome, cool. Alrighty, so these slides are quite detailed. I've tried to incorporate information from the Raise the Bar document that the internal competitions team puts out every year, as well as information from the score sheet and judging guide, and from my own personal experiences. So I won't run through every single snippet of information on these slides. I've tried to make them detailed so that if you do go ahead and enter the competition, you can come back to these when you're preparing for your mediation. But I'll just speak to some of the main points about how a mediation runs and some of the key tips that I have, and feel free to jump in throughout with questions. Otherwise, I'll leave time at the end for you guys to ask any questions. So I'm happy for that to work either way. But jumping straight into it, essentially, a mediation, as many of you will probably already know, is a form of alternate dispute resolution. I think when I was doing the competition, in fact, I didn't actually realize how valuable and important and prevalent mediation is in the legal industry. It wasn't until after I competed in the competition and then I started to work for a barrister that I realized that mediation is one of the key things that lawyers do, whether you're a solicitor or whether you join the bar down the track, or whether or even if you work in a commercial setting and will be involved in some sort of litigation or legal dispute at some point in your life, you'll probably come up against mediation. So this is really one of those skills that you can sort of start to hone at law school that will really, really help you down the track, and that will look really good on a CV and give you something really great to talk about in job interviews and things like that. So that's why I recommend participating in a mediation competition. But essentially mediations are either voluntary processes, or sometimes they're court ordered, where clients and their lawyers sit down with the other parties in the dispute in the presence of a mediator. So a mediator is like an accredited person. It's often a barrister who's taken an additional course to become an accredited mediator. And they basically sort of try and resolve their dispute in that setting. And it's super common because they're a lot quicker than trials in front of a judge, of course, and that means that they cost a lot less money, essentially. So that's what mediation is in general. So what's a mediation competition? Because obviously these things look a bit different when they're a competition in law school as opposed to an actual mediation in the industry. So there's a whole bunch of information on this slide, but essentially a mediation is going to consist of you as a student and a teammate, so two teams of two going up against each other. One person in your team will be representing the client, and one person in the team will be representing the lawyer. So I imagine a few of you have probably done some form of negotiation competition, or you've heard of it or seen one or something like that. A mediation is a little bit different to a negotiation in the sense that it involves the presence of a mediator. So the way that it'll work in the UQLS competition is that for the first few rounds, your judge will act as your mediator, and in later rounds they'll have a third party in the room who's not a judge, who will be your mediator. But the mediator is not a competitor. So those who are competing in the competition will essentially be, or part of the criteria is your ability to use a mediator. And so that means that teams that score higher in this competition will be teams that treat a mediation differently to a negotiation and learn to really use the mediator in the spirit of what a mediation actually is. And I'll get into that a little more down the track. But essentially, the key goal in a mediation is very similar to a negotiation. You want to advance your team's interests to reach a mutually beneficial outcome that not only meets your interests, but also meets the interests of your opposition. So it's not about beating the other team. It's about how well you can show your skills and use those skills to get a good outcome for your client, or for you if you are the client. In terms of logistics, it'll work very similar to the negotiation competition in the sense that each team will receive in advance to the competition a set of common facts, which will be the same for both teams. And then you'll receive a set of confidential facts, which will be private to your team, and you won't have access to the other team's confidential facts. And you'll use the information contained in those facts to prepare a mediation plan and to prepare for the mediation. And then a big part of the mediation is trying to uncover the other team's facts and find out, the truth of the matter, because that's what mediation is essentially all about. And also I should flag that the UQLS mediation competition is going to be run in accordance with the official ICC mediation rules. This slide, I've linked the rules there. So if you want to go check that out when preparing for the competition, there's a little bit more detailed information there. Alrighty, so roles in a mediation. So I'll focus on telling you about the role of the mediator, because that's obviously super important in a mediation competition. The mediator's role is basically to host the discussion. So they always open the mediation with an opening statement, and their role is sort of to narrow the dispute. It's usually quite a complex commercial dispute, and the mediator's role is to keep the peace in the room and to narrow the dispute down to the key issues in contention, and to make sure that the sort of mediation keeps progressing. So the worst thing that teams can do in a mediation is just to ignore the mediator. That will score you 0 points in the criteria. That is the criterion, I should say, that's use of mediator. And I'll show you the criteria or the score sheet a little bit later on. But the mediator isn't allowed to come up with offers or options. They're not allowed to solve the problem for you. They're not allowed to be biased, but they can help you sort of ask questions. And you can do things as a team to really use the mediator. So you might say you want to ask the mediator to write things down on a piece of paper shared between the two teams, or if there's a whiteboard in the room, the mediator can do that. You want to ask the mediator their opinion on things. You want to say, oh, Mr. Mediator or Madam Mediator, I feel like we've reached a standstill on this point. What do you suggest we do from here? How do you suggest we progress? And there's a whole bunch of ways that you can use a mediator, but it's important that in your preparation you brainstorm ways that you can involve the mediator. And this slide contains a few of the things that a mediator can do and a few of the things they can't do. So that's definitely something to have a look at. Obviously, the other roles in the mediation are the client and the counsel. So that will be you and your teammate. So the client's main role is to sort of push their, usually a client will be, say, a CEO of a company, or a member, a head of a government department or something. And so usually the client is representing more people. They're just not the legally qualified person in the room. So a client has to remain very professional. You're in a mediation setting, so you still have to act appropriately and act professionally. And usually, and this will depend on the problem, but usually it will be in character to act professionally as a client. But the client's main focus is to really push their companies or push their own narrative and push their interests. So their focus is on the more emotional narrative side of the story. They have to say, you know, this is why we've come, this is what we want. So it says here, good clients will recognize the emotional elements of the dispute, but they'll always focus on commercial solutions. So this is not a drama competition. You know, if you're representing a client, I mean, some of you who may have been involved in client interviewing, for instance, would know that the clients in that competition who are not competitors are usually encouraged to be really like weird and dramatic. This is not the same thing. So it's an important distinction to make. As a contestant, you have to remain professional, but you do get scored on how you use how you sort of divvy up the responsibilities between client and counsel. So it's important to understand that there is a distinction and you have to be strategic about it. So for instance, when I did the mediation, often the approach or the strategy that we'd take is that the client would throw all the solutions out on the table and like really, really push the narrative and dominate the opening statement. And the counsel would sort of hone in the client and sort of make it look like they were proposing a really like middle ground compromise solution, when in reality it was sort of like all part of the strategy. I don't know if that's a bit rambly. I hope it makes sense, but it's definitely something to put some thought into. So on that note, the counsel's role, I've already slightly touched on it, but essentially the counsel should focus more on the legal side of the discussion. The counsel's role is to say all the formalities. So at the beginning, the counsel should say things like, you know, we're here to have a mediation in accordance with the ICC mediation rules. You know, we want to acknowledge or abide by confidentiality, and you know, we want to negotiate in good faith, and all of those sorts of like legal things that a lawyer would say. The counsel should be the person saying that, and the counsel should also be the person that uses the mediator the most, because as counsel, you're the legal professional, you're trained to use the mediator, and they should also be the one to sort of like move the mediation along. So say to their client, all right, thank you for that, maybe we should move on to this next point. But it's important to note that there are no strict boundaries as to what the client and counsel can do. You're a team, you've got to work together. It just allows for a more sort of dynamic discussion than perhaps a negotiation competition does, where it's simply two lawyers negotiating with two lawyers, if that makes sense. And I will also note there that it is important to have relatively equal speaking time. Again, you're a team, you don't want one person dominating the conversation. You can dominate certain parts of the conversation, but overall across the 75-minute negotiation, it should end up relatively equal. Otherwise, you risk losing points. This is just a general slide on how the competition works. So each team participates in 2 rounds, and then after that, we have quarterfinals. So the top number of teams break for the quarterfinals, and then the same goes for the semifinals and the grand finals. So that works very similar to other competitions run by the UQLS that you may have been involved in already. All right, so preparation. Mediation is like a nice middle ground between like say client interviewing or perhaps negotiation, which requires quite a small amount of preparation, and mooting, which requires a lot of preparation. So it's a really nice middle ground. It's not nothing, and you do need to submit something in advance, but it doesn't require huge amounts of reading or research. It's all sort of all the preparation is sort of taken from the confidential facts and the common facts and your own brain, and maybe like these slides or the raise the bar guide, but nothing too crazy. So at a minimum, what you've got to do is read through the problems, obviously, prepare a mediation plan. This is the key difference to negotiation and client interviewing. You actually have to have a mediation plan printed out and ready to submit to your judge on the day of the competition. Otherwise, you get 0 points in that criteria, and I'll discuss mediation plans in a moment. You should also have a think about or prepare an agenda. So what kinds of issues are there at play here, and you know, what do you want to talk about? What do you want to find out about? And you also obviously have to like know your client's position on each issue and be aware of like sort of your client's key interests and the other side's interests as well. There's a bit of extra stuff here that you can do to be even better prepared. So consider, your client's priority list, prepare any clauses or statements that you think you might want to propose. Say like an issue in the mediation is like someone's reputation. And so you might want to like draft a press release or something like that that you can sort of read out in the discussion. That just shows the judge that you're extra prepared, and it gives a little more sort of substance to the discussion. You might want to brainstorm what kinds of questions you'll ask based on the facts that you have. Consider what kind of options you might propose, and also perhaps prepare your introduction, or that should really say your opening statement, which I'll also get to a little down the track. But definitely take note of the things that you have to do at a minimum. So this is pretty generic. What you should do is read through the common facts and the confidential facts and sort of identify the following information, but I won't go through that in too much depth. The mediation plan. So the mediation plan is a document that you have to prepare in advance of the mediation and present to your judge at the start of the round. There's a couple of logistical things here about the mediation plan. So it's in the rules that it can't be longer than 2 pages, and it has to have all of these margin and font and size requirements. If you don't comply with this, you do get a 5-point penalty, which is quite a big penalty. So definitely make sure you stick with this rule. So a mediation plan should include these 4 things, which I really should have bolded to make them more clear. But essentially, number 1, your mediation strategy. So this is like, what are you going to do to achieve your goals and objectives? How likely is this going to be to actually resolve the conflict? A strategy, it's important to note the difference between a strategy and a tactic. So a strategy is like your overall approach to settle the dispute, whereas a tactic might be like, one kind of thing that you'll do, like, the client will go hard with questioning and the lawyer will like hone the client back. That might be a tactic. The strategy is a little bit more holistic. And I'm going to show you an example of a mediation plan, so you might get what I mean, rather than this all being in the abstract. The division of responsibilities and tactics. So that's where tactics come in. It's a little bit different. You want to say what the client's going to do, what the counsel's going to do, and why you think this might actually work. And obviously writing all of this with reference to the problem. So, a judge doesn't want to read a mediation plan that you could submit for any mediation. If you make it through all the rounds, it's great to have a template of a mediation plan, but make sure you edit it and put in specific information about the problem. So it actually looks like you've really considered the problem at hand and you haven't just like submitted something generic that you've already submitted. Then you want to clearly set out the interests of both parties. And as I'll get to a little bit later on, interests are like at the very crux of a mediation. So a mediation is all about the underlying interests of both parties. Obviously, you'll have a really good idea of your team's interests because you have the common and confidential facts. You'll have less of a clear idea about the other team's interests, but you want to predict them and you want to show that you've thought about it, like, what might this other team be wanting when they come into this mediation? Because that's going to help you devise your strategy and devise your options and those sorts of things. Where was I? Yep. So make sure the mediation plan sets out the interests of both parties, and then you'll have your BATNA, and it's completely escaped me what BATNA stands for. I think it's best alternative to a negotiated agreement. Essentially, your BATNA is basically like, if you don't reach an agreement in today's mediation, BATNAs are also used for negotiations. That's why I say that, and that's why it has N in the acronym, but it can also be used for mediation. So if you don't reach a settlement in your mediation, what's the best outcome, what's the best alternative. And sometimes your BATNA is really, really weak. So sometimes it's like, if we don't reach settlement, then we'll probably go to trial, and our case is definitely the weaker case, which means we'll probably lose and it'll cost us a lot of money. And so that's really bad for us. Or it might be really strong. It might be that, okay, well, the other team has no money. So if we don't reach an agreement today, we probably won't go to trial, and so we'll probably be all right. We just might, lose our reputation or something like that. It's okay if your BATNA is really weak. Like, that's not your fault. That's just how the problem sort of sets it out. But it's important to acknowledge your BATNA, because your BATNA will play into your strategy. Because if your BATNA is really weak, then perhaps you're going to be willing to give more in the mediation. If your BATNA is really strong, then you can use that to justify going a little bit more hard line, and not agreeing to offers so easily. So it's the hallmark of a really good mediator or negotiator to be able to identify their BATNA and the other team's likely BATNA and make their decisions based on that. So this is an example of a mediation plan. I believe that this was probably one from the 2021 team, because it doesn't look familiar to me, but I have popped it in here as an example of what a mediation plan looks like, so you can go back and have a look and see what we actually mean by a strategy, and things like that. And as you can see, how it's been really clearly set out, our goals, our objectives, our strategy, and the likelihood of its success. They've set out the division of responsibilities. They've done interests in this like nice little table, which is a really good way to do interests, because it shows you've thought about how they conflict and how they merge together. Because again, like I said, a mediation is all about interests and how they meld together, and how you can find a solution that meets the maximum amount of interest possible. And then they have their BATNA, and obviously PRAC would have been the other team, or the other side, their opposition's name, and that they've put their likely BATNA. All right, moving on. This is the mediation score sheet. I think it's really good to have a look at this, because you know exactly what you're going to be marked on and what weight is going to be given. As you can see, this category about interests, advancing your interests, has the most points, equal with the use of the mediator. So if you just sit there silently, if you just let the mediator sit there silently, and note that some mediators will be more proactive than others. It depends on how much experience our judges have as mediators, remembering that this is the first year UQ has run the competition. But if you just let the mediator sit there and don't involve them, or you don't jump at their offers to help, you'll probably get like a score of 0 out of 16 in that category, and that's out of 100. So it's a pretty big amount of points to lose. So make sure you don't let the mediator sort of slide under the radar. And then also, as you can see, like, your mediation plan is worth 1/10 of your overall marks. If you don't submit one, you'll get 0 in that category, and vice versa. So you can have a look at all of these things: opening statement, advancing your own interests, teamwork, ascertaining other parties' interests, aka questioning, collaboration. So that the difference between teamwork and collaboration is teamwork is you and your teammate. Collaboration is your ability to work with the other team and not be like antagonistic. Developing options together is your ability to generate a wide range of options. Use of the mediator we've discussed, and mediation plan we've discussed. So this is the structure of the mediation. Again, I won't go into this too much, but it's 75 minutes in total. There's an approximate breakdown here for how much time you should spend on each part, but the general process is that the mediator opens it up, then each team delivers an opening statement, then you sort of set the agenda. So, okay, what are the issues here? What do we want to talk about? Then you have your fact-finding section where you move through the agenda items and you sort of question each other in the least interrogative way possible. Then you put all your options out on the table, you generate all your options, then you evaluate them. You decide, okay, what's a crap offer? What's like way too generous for the other team? What's way too one-sided? What's a reasonable offer? What's the best offer? And then you sort of try and reach an agreement. and then conclusion is all of those formalities. Thank you so much, blah, blah, blah. 75 minutes is a lot of time, so it's probably not the end of the world if you don't make it to 75 minutes, but 75 minutes is what's gone with in most official competitions, and I believe that's why we've settled on that time frame. So gives you plenty of time to work with. Okay, the opening statement. Also, if I'm speaking way too fast or I'm skipping over anything, please feel free to jump in and tell me to slow down. I don't mind. But the opening statement. So this is where we'll essentially, firstly, the client will start off. The requesting party will start off. Their client will go provides like an outline of the backstory, like why are we here? Then they present their team's narrative. So we were really upset when this happened. You know, we wanted to come to mediation because, and the client's key role is to ensure that they convey their team's interests. Then the counsel will come in, they'll re-clarify the interests and identify any potential legal issues that have arisen. They'll sort of communicate to the other party their BATNA. So, you know, if we don't reach a mediation today, this is what we're prepared to do. And they'll sort of go through some of those formalities about good faith and the ICC mediation rules. The responding party then essentially does the same, client first and then counsel. If you are a responding party, it's very important that you engage with the requesting party's opening statement. So even if you have done the work and pre-prepared an opening statement, that's fantastic, but you've got to be flexible. So it's a good idea to think about what you want to say in your opening statement, but you want to also acknowledge what the other party said. You don't just want to like read from a piece of paper. That's not how mediation works, and it probably won't result in a really favorable score, even if it sounds really fantastic. I want to speak a little bit to interest, because I have mentioned that word a million times so far. And that's because interests are like really, really, really important. So what we want to do is sort of focus on interest-based bargaining or interest-based negotiation or mediation, as opposed to position-based bargaining. So at the risk of sounding a little bit lame, the best way it's been described to me is in the form of like a food analogy. If you say, I want a salad, that's a position, right? And so if the person that you're negotiating with simply can't give you a salad, then you know you're at a bit of a standstill. The interest behind saying I want a salad might be that I'm hungry, I want something to eat, and I want it to be healthy. So if you can convey that interest, then the person you're bargaining with might say, well, I can't give you a salad, but I do have a veggie stir fry. And then you can say, okay, well, it's not exactly what I want, but it's consistent with my two underlying interests. So I guess we can agree to that. You're in a better position than if you had no food at all to eat. And they're in a better position because they've been able to give you something without having to commit to something that they absolutely cannot do. Right? So it's really important that you extract those underlying interests and focus on those rather than your position. So rather than saying we want a public apology, say we want to, you know, mend our reputation in the public's eye, you know? So I think that probably covers what the difference between the difference is between an interest and a position, but feel free to ask me more questions about that later on. All right, agenda setting. The mediator starts off with their statement, they invite opening statements, and then it's the agenda setting stage. The mediator sometimes asks clarifying questions, sometimes they don't, but usually this is when you really start to use the mediator. So you would say, Madam Mediator or Mr. Mediator, thank you, I think we're ready to set an agenda. Could you, you know, our team or our, you know, you shouldn't say our team, you should, you know, use the name of the party, whatever that is, it'll be in the problem, but you'll say like our team proposes the following agenda, could you please write this down? And then the mediator might write it down, and then the mediator might invite the other team to propose their agenda, and you sort of work through it in that way. Bearing in mind that an agenda is not the structure of the negotiation. The structure of the negotiation is, of the mediation, sorry, I keep saying negotiation. The structure of the mediation is this in this slide here. But the agenda is like the structure of the fact-finding part of the mediation. So, and that goes for a good like sort of 10, 15, 20 minutes. So you set your agenda. So there might be like 4 issues that are being raised in the facts that you want to sort of find out more information about. So you set your agenda for that. And then of course you move on to your agenda, which brings me to my next slide. So you move through the agenda items. You want to demonstrate good questioning technique. So this is something that will score you points in the criterion of discovering the other party's interests. And essentially, that means asking a variety of open-ended and closed questions. So you're not pretending to be police detectives. You're not interrogating someone in an interview room. You need to keep a really collegiate and collaborative atmosphere in the mediation room. And so that means not pounding the other team with questions. You might ask a question, invite another question back. It's got to be an open discussion, and it's got to be really pleasant and professional and cordial. Otherwise, you'll lose points. Good questioning technique is using a variety of questions. And the other thing that's really, really important and that scores you heaps of points is active listening. So mediation is largely like buzzword bingo. The more mediation phrases that you can use, the better. So a judge will be listening for you to say things like, thank you for that. What I am hearing is that your key interest is financial compensation. Is that correct? You know, or I hear that your interests are X, Y, and Z, or do I understand correctly that blah, blah, blah? It's psychologically proven that if you repeat what somebody says back to them, they like you more. It is like an actual thing. So try and use that in mediation in the sense that like if somebody said something and you go, right, yes, and you repeat back to them what they just said, they feel that you listen to them. Whereas if you're fixated on these preconceived ideas of what they want and you're not listening and you're, you know, furiously scribbling on a piece of paper while they speak, it doesn't produce a nice environment, and it doesn't make the other team think that you've heard them and think that you've understood them. And it really sort of like heeds the outcome of the mediation. So using those active listening phrases to really indicate to the judge and to the other team that you've listened and that you're identifying their interests and you're adapting what you thought their interests were to what their interests actually are, that's going to score you huge points. And so that's really, really important. All right. So the next part of the negotiation, the next stage is the generating, presenting, and evaluating options. So the first stage is generating them, and the second stage are generating and presenting them. They kind of come together, and then evaluating them to reach an agreement. So in a mediation, perhaps as opposed to a negotiation or other styles that you might have encountered before, it is actually really valuable and really important to like put every option on the table. So as part of your preparation, you should be thinking about all the possible options that you can present, even if they're really bad, like even if they're really favorable to you or really favorable to the other side, you need to put all your options on the table. And then you need to use the mediator to help you decide an option. So you need to say to the mediator, can you write these down? Or, you know, what do you think about this option? Do you think that this is fair? Do you think that this is too favorable to us? Do you think that this is too favorable to the other side? By using the mediator in that way, you're sort of gaining points in that criteria, and you're also gaining points in the sort of option generation phase. So by putting all the options out on the table, that's really important. And it will also allow you to frame the actual result that you want, or the actual solution that you want to go with, as being the most desirable, because of course you're being scored on your ability to reach a middle ground, compromise, a mutually beneficial solution. So if you propose 5 options and 4 of them are like not quite that good, and you go with the one that is like quite fair, then you're going to get the best outcome for you while also appearing to be very fair. So it's all very strategic. The mediator also, like, their job is to like get rid of like crazy solutions, crazy options. So that's why you actually can afford to put them out there without getting sidetracked. I wanted to mention MESO tables. So they're called that stands for multiple equivalent simultaneous offers. I meant to grab an example of a MESO table, but I completely forgot. But you can look them up. Essentially, it's like if you have, they're really good for if you have sort of like a lot of figures or dates or things like that floating around in your options. Like say, you know, option 1 might be to like pay the other team $50,000 in 1 month, or then to pay them $100,000 in 1 year, or something like that. You know, if you have a lot of different floating figures, you can do up a MESO table. If you think you want to use one or you want to know more, definitely look it up. It can explain it much better than I can right now in this weird abstract way. But they're a really good thing to consider when generating your options. Once those options have been put out on the table, you then use the mediator to help you evaluate them. And then hopefully you can find a solution that suits everybody and reach an agreement. I've kind of put my slides in a slightly wrong order, but agreement is here. You should try and reach, it's pretty simple. You should try and reach a mutually beneficial agreement. You're going to be rewarded for using strategies that facilitate progress to that agreement. So you're not going to be rewarded for stalling the negotiation or like taking too long on questioning or not being cooperative, but you will not be penalized if you don't reach an agreement. Like, mediations take days and days in the real world, not 75 minutes. So totally understandable if you don't reach an agreement, but it is the ultimate goal, so you should like try and do that. Caucus is another component of a mediation that differs to any other competition you'll have done before. So this is another thing that's quite unique to mediation as a form of alternate dispute resolution. So you have the option in a mediation competition to call a 5-minute caucus at any point in the 75-minute mediation. Now, caucuses can be called in 2 separate ways. You can ask the other team, so the other counsel and client, to leave the room, and you can have a 5-minute chat with the mediator. Or you can ask like both counsels or both clients to leave the room, and then like both lawyers and the mediator can have a chat. From a strategic point of view, given that this is a competition and like you're not a legitimate client and you're not a legitimate lawyer, the caucus that you're most likely going to call is going to be the normal caucus, not the cross caucus, where the other team leaves the room and you and your teammate get a private chat with the mediator. And that's just a way, I mean, it can be like helpful, but the main purpose of it is to like show that you're using the mediator. So it is a good thing to do, although you won't score points for calling a caucus and then having nothing to ask the mediator. Often, and there's some examples down here of the appropriate use of a caucus, but it's essentially like you wish to clarify something, or you know, you're concerned about something in your confidential facts and you're not sure whether you should disclose it, and you want to like chat with the mediator about it with the other team being out of the room, or perhaps you feel like all the options on the table, like none of them are good for you, and you want to ask the mediator what you can do about this. There's a whole bunch of ways that you can use the mediator to call a caucus, so it is something to think about. It's kind of like the equivalent of a break in negotiation, except that you do get points for using caucus appropriately, because it is a way that you can really engage with the mediator. All right, really done. Okay, what to bring to a mediation. that's, oh, I actually didn't really edit this from the negotiation slides, oops, but it's pretty much the same. Obviously, one important thing that is not on there, but you absolutely must bring is your mediation plan. Don't forget that. Bring a copy for yourselves and then a copy for the judge. And of course, if you are lucky enough to make it to the rounds of the competition where there are more judges, it's always a good idea to bring a copy for every judge. That always makes us happy. Bring some sort of note-taking material. Obviously, if you've written out an agenda, bring that. If you've drafted an opening statement or have notes on that, bring that. Bring a copy of your confidential facts, and have all of these physically printed. Try not to use a computer screen. I don't even know if you're allowed to, actually. I might have to check that in the rules, but either way, it's not a very good look. So try and bring these documents printed out on paper with a pen. Wear professional dress. Bring a timing device. It can be your phone on airplane mode, but something to like make sure that you're, the mediator will sort of time as well, but it's always good to have that as a backup. Props you don't need, and room setup you don't really need. So ignore that. I will edit that before I send it out to you guys. All right, conduct in the mediation. I talked about this a little bit earlier. Even though one member of your team is going to be a client, don't do anything dramatic, like don't cry unless you're actually crying, but like don't pretend to cry. Like make sure you keep a really like nice working relationship with the other team. There is more capacity for the client to demonstrate emotion than the counsel, but it should be professional emotion. So you can have a lot of conviction in the way that you speak and the things that you say, without being dramatic or rude or coming off as crazy or anything like that. Good teams are going to demonstrate flexibility, active listening, empathy, those kinds of qualities. And also a really important note on ethics. You are not allowed to lie, but you also should never reveal information that you're explicitly instructed not to reveal. So if your confidential facts say under no circumstances should this be revealed to the other team, don't reveal it to the other team. Maybe reveal it to a mediator in Caucus, but don't reveal it to the other team. So that can be a bit of a tension, right? Because sometimes you might be directly asked about something that you're not allowed to reveal. Don't lie about it. Just say, I cannot reveal that information. Yes, sometimes that is an answer in and of itself, fair enough, but never lie is at the very top of your ethical obligations, below not revealing confidential information. And then also like make sure your outcomes are reasonable and within the instructions of your client. That's perhaps less relevant because your client is going to be like in the room, but you know, definitely don't agree to anything that, you know, if your client is like the CEO of the company, and the company is the party in the dispute, then obviously like as the client, don't agree to something outrageous that your company is not going to like, but that kind of goes without saying. Okay, where do I find more information? I've touched on some of these things a little bit earlier. You can read the UQLS competitions rules. In fact, if you're entering the competition, they're not super long. I really encourage you to do that just so you know what you'll lose points for and things like that. Read Raise the Bar, the competitions handbook. I believe it's on the UQLS website and it's also sort of circulated on Facebook. It is super, super helpful. In fact, so much of the content in the slides has been taken from Raise the Bar. I can't remember off the top of my head who wrote the mediation contribution. It wasn't me, but it was brilliant. So definitely have a read of that. Watch how-to videos on YouTube. For mediation, I don't know if the UQLS has actually done an example mediation video. I don't think they have. But what I would encourage you to do is look up the ADC ICC mediation competition, which is the international competition that UQ has entered externally. They have filmed their finals back in the pre-COVID days, when they were actually allowed to happen in person. They film their finals and upload them to YouTube. So that's like a good example of the top standard in the world of students in mediation competitions. Join the UQLS competitions group on Facebook, and contact the internal competitions team. So Ben, who's sitting in today, or also feel free if you have a specific like mediation related question. I'm really happy to answer it as well. So you can email me too. Ben's email is here on the slide, vpinternalcompetitions@uqls.com. And you can email me at, my name is matisse.reed@gmail.com. So you can email me there. Does anybody have any questions? I know I just talked at you for the better part of an hour.